Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation, your free video resource to assist in subrogation and recovery matters. If you like podcasts, check out our On Subrogation podcast that explores many of these same issues in a greater discussion. In this video, we'll be discussing conflict of law and specifically how it relates to statute of limitations. What's a conflict of law? Well, it's a scenario where two states may have interest in having their law applied to a specific claim. If we have an Ohio motorist that drives down to Florida on vacation and gets into a motor vehicle collision, that defendant potentially lives in Ohio, but the loss happened in Florida. We now have two states that may have an interest in having their law applied to that particular claim. In the realm of statute of limitations, we have an issue of Florida has a 4-year statute of limitations for most negligence actions. Ohio only has a 2-year statute of limitations for most negligence actions. It's going to make a big difference for when that suit must be filed depending upon what state law applies. So how do we know what state law applies? And there's a long history and treatises out on what analysis must take place in these conflict of law situations. The area of law is way too big to cover in this short video. So the general rule is we want to break it down to what's a substantive law or a procedural law. A substantive law is one that governs the duties and obligations of parties in their regular conduct. Think about rules of the road, speed limits, whether you have to stop at a stop sign, what a yield sign means, driving furthest to the right when you make a right-hand turn. All of those things are substantive laws. They govern the conduct. Procedural laws are the rules that are used to enforce those laws in the administration of justice. For our purposes, most cases, a statute of limitation is a procedural rule. And the rule that most courts follow are they will follow the substantive rules of where the loss happened, but they'll follow the procedural rules of where the lawsuit is filed. So take our Ohio driver getting in an accident in Florida. If the suit is filed in Florida, Florida's going to apply the substantive rules, and it's also going to file its own procedural rules, which would mean there would be a 4-year statute of limitations to file suit. If the lawsuit were filed in Ohio, Ohio would still follow the substantive rules of Florida, whether or not there was a stop sign, whatever the speed limit was, all of those things, but Ohio would apply its own statute of limitations as that's a procedural rule. The big difference being you only have 2 years to file if you're going to file in Ohio, but 4 years if you're going to file in Florida. You can see the predicament that this causes when, if you're pursuing a subrogation claim and you're relying on a 4-year statute of limitation, but you decide you would rather file where the defendant lives, and suddenly you find yourself having a shorter 2-year statute of limitation. One of the ways to approach this is you always want to look to see what parties do I have, and potentially do I have 2 states that may be involved. You want to look at where the loss happened, where the potential defendant or defendants live, what's their state of residence or domicile, and you may also need to consider what state you wrote your policy covering the insured on. That could give you 2 or maybe even 3 states where you have to consider what their law may be. You want to look to see what are the potential statute of limitations and are any of them shorter. To show exactly how complicated this can get, let's take this time a New York driver who's driving across country but unfortunately gets into a car accident while they're in Ohio. We have a loss location of Ohio and a defendant that lives in New York. So those are our 2 states where suit could possibly be filed. If we were going to file in Ohio, the substantive law would be where the loss happened, the rules of the road, and the procedural law would require a suit to be filed within 2 years. But since the defendant is in New York, we could also file in New York, and the procedural rule there is a 3-year statute of limitations. With the big exception that New York has a borrowing statute. And under that statute, New York is going to look at the statute of limitations that would apply for New York, but also the statute of limitations where the loss actually happened. And it's going to take the shorter of the 2. So even though you may look at this and say, well, I have a New York defendant, I'm good to file within 3 years of the statute of limitation. If you're filing in New York's going to look at their 3-year statute of limitation, but also the statute of limitation of where the loss took place. And in the case of an Ohio statute, which is only 2 years, if you filed after that point, you're at risk of blowing the statute of limitations. Again, it's very complicated and it can get complex when you're dealing with each state and what they deem, whether it's a substantive law or procedural law, because not all states hold that a statute of limitations is a procedural law. But if they do, then of the states, which state is it going to follow? And is there anything like a borrowing statute? Again, impossible to cover all the different scenarios in a short video like this, but certainly an emphasis on how important it is to understand each of the states where the loss is going to happen and what your options are in order to protect your claim. For On Subrogation, I'm Jason Sullivan of Rathbone Group, and that's the long and short of it.